Hi, Tony DeWitt here, Missouri appellate attorney and a guy who likes to make the law make sense on YouTube. Well, last week, Justice Clarence Thomas caused about a third of the population to lose their minds when he upheld the Second Amendment. That should not be controversial, but apparently it is. I'll have more on that in just a moment. In what will now be called the Bruen decision, Judge Thomas held that the Second Amendment right to keep and bear arms means essentially that a state cannot regulate that out of existence. In other words, it can't place so many restrictions on the right to keep and bear arms outside the home that a normal person can't get a permit to carry. Now, it's perfectly okay, according to the Supreme Court, to keep felons and other miscreants from having firearms and hurting people with them, and that's fine. But what you can't do is you can't say, well, you need to show a special need to have this, because the Constitution doesn't say anything about special needs. The opinion itself is a tour de force, and I'm going to break away to some screenshots here so you can kind of get a feel of what this opinion is really all about. So here we go. Most of these are from the syllabus of the opinion, which is actually quite well done and which I think provides a good summary of the case, but you really should read the entire case. The court starts off with, the state of New York makes it a crime to possess a firearm without a license, whether inside or outside the home. An individual who wants to carry a firearm outside his home may obtain an unrestricted license to have and carry a concealed pistol or revolver if he can prove that proper cause exists for doing so. An appellant satisfies the proper cause requirement only if he can demonstrate a special need for self-protection distinguishable from that of the general community. Petitioners Brandon Koch and Robert Nash are adult, law-abiding New York residents who both applied for unrestricted licenses. On their generalized interest in self-defense, the state denied both their applications. Petitioners then sued respondents, state officials who oversee the process of licensing, for declaratory and injunctive relief, alleging that respondents violated their Second and 14th Amendment rights by denying their unrestricted license applications for failure to demonstrate a unique need for self-defense. The Supreme Court often does. It didn't want to bury the lead. It goes right to the holding. New York's proper cause requirement violates the 14th Amendment by preventing law-abiding citizens with ordinary self-defense needs from exercising their Second Amendment right to keep and bear arms in public for self-defense. And the court says in District of Columbia v. Heller and McDonald v. Chicago, the court held that the Second and 14th Amendments protect an individual right to keep and bear arms for self-defense. Under Heller, when the Second Amendment's plain text covers an individual's conduct, the Constitution presumptively protects that conduct, and to justify a firearm regulation, the government must demonstrate that the regulation is consistent with the nation's historical tradition of firearms regulation. Since Heller and McDonald, the courts of appeal have developed a two-step framework for analyzing Second Amendment challenges that combines history with means-in scrutiny. The court rejects that two-part approach as having one step too many. Step one is broadly consistent with Heller, which demands a test rooted in the Second Amendment's texts and informed by history. But Heller and McDonald do not support a second step that applies means-in scrutiny in the Second Amendment context. Heller's methodology centered on constitutional history and text. It did not invoke any means-in test such as strict or intermediate scrutiny, and it expressly rejected any interest-balancing inquiry akin to intermediate scrutiny. So what does all this mean? Well, first of all, strict scrutiny, intermediate scrutiny, rational basis, they're out the window. We don't look at those anymore. What we look at is history and text of the Constitution. That essentially means that in order to justify some kind of limitation on the right to keep and bear arms, period, not just the right to keep and bear arms out of the house, the right to keep and bear arms generally, the first thing you have to look at is the history. Did, at the time of the founding of the nation, at the time of the 14th Amendment, was such a regulation in existence, and was it tolerated? Was it incorporated? And in most cases, the answer is no. So, for example, limitations on magazine size. Well, at the time of the founding, and certainly at the time of the 14th Amendment, there were no magazines for firearms. And if there had been, it's just speculation to say whether or not Congress or the states would have regulated them. So I suspect that all of these cases that relate to magazine size and magazine limitations are going to be out the window. And that's going to be a good thing for people who possess ARs and AKs and who like to shoot them. Now, all of the people who are worried about school shootings and that sort of thing, again, the answer to the school shooting thing isn't to limit magazine size. People will just carry more magazines. If you limit the magazine size to 10 rounds, which is the only reasonable limitation you could impose, I think, and then what's the guy do? Instead of taking one 30-round magazine, he takes, 6 10-round magazines. So you're really shooting yourself in the foot by regulating magazine size, and what you ought to be doing is hardening schools just the way we've hardened courthouses and airports. They need to have a level of security that is consistent with the value of the things contained therein, and children are our most valuable resource. It doesn't make any sense not to protect them. So all of these things that were initially believed to pass scrutiny because the courts were applying these means-end tests are now going to be out the window. Now, does that mean that the Second Circuit and the Ninth Circuit and maybe even the Seventh Circuit won't refuse to follow this, or will interpret it in a way that makes it completely worthless? Absolutely not. That's exactly what's going to happen. The Supreme Court is going to have to rule on this again, much the way they've had to rule on Heller, and say, look, guys, we mean this. We mean what the Second Amendment means. That's just the way life works. So the rest of the opinion is, like I said, an absolute tour de force. It essentially says there is no history that accords with limiting the right to keep and bear arms outside the house, and that you can't regulate it in such a way that no right really exists, which is essentially what New York did here. So, as you might guess, there are 3 judges on the Supreme Court who didn't join the opinion, and Judge Breyer, who claimed credit, he actually crowed about how he had watered down Heller, gets to crow this time about why the opinion is wrong. Except this time, before you ever get to Breyer's opinion, you get to Judge Alito's exceptional concurrence, which just really kind of slaps Judge Breyer around like a redheaded stepchild. Let's look at some of those quotations. So after joining the opinion of the court, the Justice Alito says, much of the dissent seems designed to obscure the specific question that the court has decided, and therefore it may be helpful to provide a succinct summary of what we have actually held. In District of Columbia v. Heller, the court concluded the Second Amendment protects the right to keep a handgun in the home for self-defense. Heller found that the amendment codified a pre-existing right, and that this right was regarded at the time of the amendment's adoption as rooted in the natural right of resistance and self-preservation. The inherent right of self-defense, explained, is central to the Second Amendment right. Although Heller concerned the possession of a handgun in the home, the key point is that we decided that the people, not just members of the militia, have the right to use a firearm to defend themselves, and because many people face a serious risk of lethal violence when they venture outside their home. The Second Amendment was understood at the time of the adoption to apply under those circumstances. The court's exhaustive historical survey establishes the point very clearly, and today's decision holds the state may not enforce a law like the New York Sullivan Law that effectively prevents its law-abiding residents from carrying a gun for this purpose. That is all we decide. Our holding decides nothing about who may lawfully possess a firearm or the requirements necessary to buy a gun. Nor does it decide anything about the kinds of weapons that people may possess, nor have we disturbed anything we said in Heller or McDonald. He then goes on to say, in light of what we have actually held, it's hard to see what legitimate purpose can possibly be served by most of the dissent's lengthy introductory section. I would use the word screed. Why, for example, does the dissent think it is relevant to recount the mass shootings that have occurred in the recent years? Does the dissent think that laws like New York's prevent or deter such atrocities? Will a person bent on carrying out a mass shooting be stopped if he knows that it's illegal to carry a handgun outside the home? And how does the dissent account for the fact that one of the mass shootings near the top of its list took place in Buffalo? The New York law at issue in this case obviously did not stop that perpetrator. What is the relevance of statistics about the use of guns to commit suicide? Does the dissent think that a lot of people who possess guns in their homes will be stopped or deterred from shooting themselves if they can't lawfully take them outside? As you can see, Justice Alito pretty much dispatches the arguments raised by the more liberal wing of the Supreme Court. If you have a chance, you should read his full dissent. Again, like Judge Thomas's full opinion, it is very well done. I have to say I'm pleased to see this interpretation of the Second Amendment take hold. We've always been afraid, those of us who own guns, that it would be walked back by a future court, and we have to hope that that doesn't occur. I have to say that I think this is a good opinion. I think it will have a great deal of societal good in the end. And I believe Justice Thomas really is probably the greatest living Supreme Court justice that we have. It's worth noting that Judge Roberts joined this opinion, which is something I didn't really expect him to do. I'm glad that he did. And I would also add that some of the judges that I expected to be more forceful on this issue in their concurrences were not. So it's worth thinking about what the makeup of the court is and how that might affect future rulings. But at least for right now, the rule is that you do get to regulate the right to keep and bear arms, but you can't regulate it out of existence. Hopefully you found what we did here helpful. And if you would, I'd really appreciate it if you drop a comment down below. If you haven't already, go over here and subscribe to our channel. Tap on the notification bell so you can be notified whenever we do a video. And otherwise, thank you so much for watching and have a terrific day.